Hello friends, in the series on the income tax cases, today we will discuss the case of JMJ Essential Oil Company versus Commissioner of Income Tax. This case has been reported in 453 ITR at page number 754. The matter has been decided by Supreme Court and the date of the judgment is 13th February 2023. As all we know that in these cases a lot of assessments are being done in the name of bogus purchases, bogus sales, where the department alleges on the assessee that the assessee has tried to accommodate his unaccounted money through bogus sales. Generally, the perception is that when the additions are done, the additions are so heavy that at that time the assessee even do not think about the penalties to be levied on the assessee. But when the assessment orders are passed, they are being confirmed by the CIT appeal. The department is very eager and very fast in imposing the penalty on the assessee for these bogus sales and purchases also. So the assessee do not forget the penalties, and all the replies at the time of the assessment, all the submissions at the time of the CIT appeal should be given in such a fashion that they should protect the assessee from the unforeseen penalties which may arise in the future also. The provisions are like that even if the assessing officer does not levy the penalty, does not initiate the penalty, even the CIT appeal has the power to initiate and impose the penalties. So the penalties cannot be ignored at any cost. In this case, the department has proven beyond doubt that the assessee has introduced his unaccounted money through the channel of bogus sales, and the only plea of the assessee from the assessment level and to the ITAT level was that the assessee has made sales and all the sales has been accepted by the VAT department, VAT has been paid on that, so the sales cannot be termed as bogus. As far as the quantum appeal are concerned regarding the tax, the matter was already against the assessee and the assessing officer has also levied the penalty, which was also confirmed by the CIT appeal. This case is regarding the penalty matter. But when the assessee moved to the ITAT, somehow ITAT gave relief to the assessee on the point that since the VAT department has not challenged the sales of the assessee, so it cannot be said that the sales are bogus. But when the department moved to the High Court restored the penalty levied by the learned assessing officer by saying that all the facts were against the assessee. The only point on which the assessee was contesting was that the sales has been accepted by the VAT department, VAT has been paid, so it is a conclusive evidence that the sales are not bogus. But High Court was not convinced with this point, and the High Court said that only on the basis that the sales has been accepted by the VAT department, the assessee cannot escape from the allegation of the bogus sales, and this is a fit case where the penalty should be imposed on the assessee. When the assessee moved to the Supreme Court on the same point, the Supreme Court was also with the learned assessing officer and said that the penalty which has been levied by the learned assessing officer under section 271 subsection 1 clause C for the allegation that the assessee has introduced his black money or unaccounted money through the channel of bogus sales was correct, and the assessee cannot escape from the penalty only on the ground that the sales has been accepted by the VAT department and the VAT has been paid on that. So friends, there is no doubt that we should take this point in our submissions, but if we will try to fight our matter only on this point, then it can be very dangerous. It should be supported with other grounds also. At the end of this video, once again I am repeating the name of the case, The name of the case is JMJ Essential Oil Company versus Commissioner of Income Tax, and this case has been reported in 453 ITR at page number 754. The matter has been decided by Supreme Court and the date of the judgment is 13th February 2023. Thank you, friends.